Hi, and welcome to Creepy Crime Story, where the darkest truths aren't imagined, they're real. Bolingbrook, Illinois, Sunday, March 1st, 2004, evening. A welfare check opens a quiet townhouse. Upstairs, a 40-year-old mother, Kathleen Savio, is found face down in a dry bathtub. Within minutes, responders document an apparent accidental drowning. Years later, the very same room will anchor a homicide crime that survives appeal. For now, this is a timeline, not a verdict. Late afternoon turns to dusk with unanswered knocks and calls. Neighbors arrange entry with a locksmith. The house is secured. There are no obvious signs of forced entry. The staircase to the primary bath is narrow, the hallway silent. The first person into the bathroom reports a body in the tub, no visible water, and no bath linens set out for use. Responding officers and EMS arrive within minutes and begin standard checks: scene safety, visual assessment, timestamps, and photographs, according to police reports and contemporaneous media. The initial posture is straightforward: accidental fall in a bathtub. An inquest will sort out the details. On scene, the working notes are clinical. The tub surface appears dry. There is no waterline on the porcelain. No soaked bath mat is underfoot. These are observations, not conclusions. Logged so the medical examiner can reconcile injuries with environment. The body is pronounced, and later that night the decedent is released to the coroner's custody for full examination. Neighbors provide brief, practical context. Weekend contact attempts failed. Worries rose when routine calls went unanswered. The welfare check is recorded as the trigger for entry. No 911 call from the victim that weekend appears in public reporting. That absence becomes the first piece of negative evidence on the timeline. It will matter only if other data points line up. This first pass remains deliberately narrow. Investigators preserve the staircase and bath area, secure the front entry, and document who crossed the threshold and when. The goal is continuity: who saw what, in what order, and at what time. Minute-by-minute notes will travel with the file to the morgue, where the body becomes the scene. In a case that begins with a dry tub, sequence is everything. It is natural to ask for theories. That is not what this chapter is for. The record at this moment offers three anchors: a quiet townhouse with locked access, a dry bathtub inconsistent with prolonged water exposure, and a death logged as accidental pending inquest. If those anchors hold, the story stays simple. If later evidence pushes against them, the posture will change. As one veteran investigator likes to say, the data decide. Personal note for viewers: in towns like Bolingbrook, deaths inside homes ripple beyond families. They test how well a community trusts its procedures. If you've ever wondered why cases like this move slowly, this is why. A clean chain of custody beats a fast headline. Kathleen Savio's body was transported from her Bolingbrook townhouse to the Will County Coroner's Office on the night of March 1st, 2004. From that point forward, the investigation no longer revolved only around the scene in the bathroom. The remains themselves became the primary source of evidence. In homicide work, pathologists often say the body is its own crime scene. The case file confirms that principle in stark detail. At intake, standard procedures were followed. Identification was confirmed, personal effects cataloged, and the remains secured. The autopsy was scheduled for early the next morning. In 2004, the context was limited. First responders had observed no forced entry, a body in the bathtub, and no obvious external threat indicators. The coroner's jury convened soon after and returned a verdict of accidental drowning. Their reasoning leaned on the assumption that a slip and fall in the bathroom could explain the scene. The jury notes preserved in the record show little debate beyond this conclusion, but the autopsy itself carried details that sat uneasily with that finding. Examiners documented a scalp laceration, bruising across the body, and no water in the lungs consistent with prolonged submersion. The skin and hair bore none of the saturation typical in bathtub drownings. The tub at the residence had been dry, a fact already logged by officers on scene. In 2004, those anomalies were noted but not pressed. Without external pressure to question the narrative, the accident finding stood unchallenged. 3 years later, the circumstances changed. In October 2007, Stacy Peterson, Drew Peterson's fourth wife, was reported missing. Public scrutiny of Peterson's marital history prompted investigators to re-examine prior incidents, including Savio's death, A Will County judge authorized the exhumation of her remains in November 2007. Chain of custody records show the exhumation was handled under strict protocol, with law enforcement and forensic personnel documenting each stage. The casket was transported under seal to a forensic facility for re-autopsy. On February 21, 2008, forensic pathologist Dr. Larry Blum conducted the second autopsy. His findings shifted the classification decisively. The cause of death was still drowning, but the manner was ruled homicide. He identified blunt force trauma inconsistent with an accidental fall. The bruising suggested a physical struggle. The laceration on the scalp could not be reconciled with a simple slip. Blum's written report emphasized that the environment described in 2004, the dry tub, the lack of wet hair, the absence of a waterline, did not support an accident scenario. A second independent pathologist, Dr. Michael Baden, reviewed the case shortly after. He too concluded that Kathleen Savio's death was a homicide. Having two separate forensic authorities agree on this point gave the case legal weight. Prosecutors now had confirmation from multiple experts that what had once been labeled an accident was in fact the result of foul play. The morgue files also contain photographs from both autopsies. The visual record highlights the inconsistencies: bruises on the torso, a laceration inconsistent with a fall against smooth porcelain, and the absence of telltale fluid accumulation that drowning cases typically exhibit. These images, introduced years later at trial, were presented clinically, stripped of speculation, yet they undercut the accident narrative that had closed the file in 2004. By placing the two autopsies side by side, the contrast is clear. In 2004, the file closed quickly, relying on surface impressions. In 2008, with renewed scrutiny and better forensic context, the same body told a different story. This pivot demonstrates why re-autopsy powers exist, to correct earlier errors when new facts demand it. Without Stacy Peterson's disappearance, Savio's death might have remained sealed as an accident. Instead, forensic science forced the record open. The morgue, often overlooked in public discussions of homicide cases, proved pivotal here. Every step, from chain of custody at exhumation to the independent review, added credibility. Courts later leaned heavily on these findings to establish homicide as fact, not speculation. The autopsy results did not solve the case outright, but they gave investigators the authority to treat Savio's death as a crime, not a misfortune. When the ruling on Kathleen Savio's death shifted from accident to homicide in 2008, investigators had to return to her Bolingbrook townhouse. The same bathroom that once carried the label "tragic misstep" was treated again, this time as a possible crime scene. The reprocessing was not about reliving discovery, but about examining every overlooked detail with sharper eyes and clearer context. The bathroom itself stood at the center. In 2004, first responders had noted a dry tub and no forced entry. Those details were recorded but not pressed. 4 years later, they became anchors for suspicion. Forensic teams documented the porcelain surface, smooth and without waterline residue. If Kathleen had drowned in a full tub, some sign of standing water should have remained. Investigators ran controlled checks with water levels, measuring how residue would appear along the edge. None of those expected marks were present in the photographs or logs. Locks and latches received renewed scrutiny. The front door showed no tool marks or evidence of tampering. Windows were intact, screens undisturbed. The narrow stairwell to the master bath had no scuffing or displaced objects to suggest forced passage. In procedural terms, this meant entry was achieved either with a key or by invitation. A burglary scenario could not be supported. That single fact shifted the profile of any potential suspect pool toward those with direct access. The bathroom layout itself was mapped with precision. Investigators measured the distance from tub rim to floor, from faucet to tile, and angles where a fall might have produced impact injuries. They compared those angles to the bruising described in the 2008 autopsies. The patterns did not match cleanly. Some injuries were consistent with blunt force, but not consistent with striking smooth surfaces in that environment. The conclusion was careful. The injuries suggested physical struggle, not a single accidental fall. Outside the bathroom, the rest of the townhouse appeared orderly. Towels in the hallway were folded, toiletries aligned, and no overturned furniture was found. There was no evidence of theft, no valuables missing. This quiet order added weight to the homicide classification. In homicide investigations, absence matters. No sign of ransacking implied intent was focused on Kathleen, not on property. Neighbors were again questioned in 2008. Their accounts remained consistent. No loud noises, no broken glass, no unusual visitors. The lack of disturbance fit with the lack of forced entry, but it also left investigators with a troubling silence. No one outside the home could place a suspect at the scene. Investigators also reviewed vehicles linked to the home. Savio's own car was parked in its usual spot, aligned properly. No evidence of tampering was documented. There were no reports of unfamiliar cars parked nearby that weekend. In a suburban setting where surveillance cameras were rare in 2004, that meant another gap. No visual record of who might have come or gone. Forensic processing in 2008 was deliberate and slow. Every hinge, latch, and surface was tested and photographed. Latent print efforts turned up only prints consistent with residents. No unknown fingerprints or foreign DNA were reported in the public record. That absence added to the pattern. The suspect left little behind, or investigators lacked the benefit of technology that would become standard later. The value of this re-examination was not in finding something entirely new, but in reframing what had already been there. A dry bathtub, a secured home, and injuries inconsistent with an accident. Each detail was small when viewed alone. Together, they formed a forensic picture incompatible with the 2004 verdict. In many communities, a home is the most private space. The idea that someone entered, caused fatal harm, and left without trace unsettles more than just investigators. It raises questions about access, trust, and opportunity. Who had keys? Who could walk in unnoticed? In cases like this, the quiet details often matter more than dramatic ones. With the room mapped and access narrowed, the clock moved from walls and fixtures to phone traffic. Investigators obtained call detail records tied to the Savio residence and to numbers associated with close contacts, including the ex-spouse. In 2004, there were no smartphone pings, no app traces, no GPS breadcrumbs, only carrier logs that list who called whom, timestamps to the minute, duration, and when available, the serving cell site. The goal was simple: test every stated movement against an objective signal path. The weekend window was finite, late Friday into Sunday, ending with first responders arriving within minutes of the welfare check. With no 911 activity on Kathleen Savio's line during that period, the only official clock inside her communication life came from outgoing and incoming calls. Analysts plotted those calls on a linear timeline and cross-referenced them with known events. Neighbor contact attempts, the locksmith entry, the moment responders documented the bathroom. Each verified call anchored a point. Every gap became a question. Dark intervals mattered. In a 2004 suburb, quiet lines could mean ordinary life, errands, sleep, a dead battery, or they could mark opportunity. Analysts were careful not to infer beyond the records themselves. Instead, they overlaid those gaps with statements collected in interviews. Who said they were at work? Who said they were home? Who said they were trying to reach Kathleen? The carrier's timestamps either supported those statements or left them exposed. When a witness claimed to be on the phone around dinner, the logs offered the exact minute. When someone insisted there was constant checking in, the record showed whether that traffic existed. Cell site data, where available, added only course location. In 2004, a handset connecting to a sector could place a device within a broad arc. It could not track turns, driveways, or precise addresses. Investigators used those arcs to test plausibility, not to draw a map. If a person placed themselves many miles away while their phone repeatedly connected to towers commonly serving Bolingbrook, that contradiction would flag for follow-up. If the calls in and out consistently rode towers that made sense for a stated schedule, the records would quiet suspicion rather than fuel it. Analysts also compared billing cycles and any long-distance charges visible in the logs to see whether the weekend deviated from a subject's normal behavior. Sudden bursts of short calls, unusual late-night dialing, or complete silence during hours when a line is usually active. Those patterns can be as useful as a single incriminating call. Nothing in this pass was treated as proof on its own. The strength of call detail work is cumulative. The more an explanation must bend around the timestamps, the weaker it gets. During the 2012 trial, jurors asked to see phone records tied to the death window, underscoring how central these logs had become. The court provided the records back to the jury room. That request told investigators something they already knew. When the physical scene is quiet, the timeline speaks. In this case, it spoke in clipped entries, start times, end times, numbers dialed, just enough to check stories against the clock. One segment drew particular attention, the late evening period before neighbors escalated to a welfare check. If someone claimed active attempts to reach Kathleen later that night, the logs either confirmed those dials or showed nothing at all. The same applied to assertions of being unreachable because of poor coverage. Cell site connections, even when coarse, revealed whether a handset was powered and negotiating with the network. A powered device leaves a signature simply by participating in the system. A dark phone during a claimed period of calls is the kind of contradiction juries understand without a tutorial. Investigators were disciplined about the limits of 2004 telecom. They did not try to divine motive from minutes used or towers selected. They used the records to mark who was active, when, and generally where a handset was likely operating. They kept the questions narrow. Did the timestamps align with the stated routine? Did any handset's activity or lack of it create an opening wide enough to matter? Did two accounts place the same person in two places at once? Where the answers strained credulity, interviewers went back for clarifications and preserved those exchanges for court. A small but important factor, the absence of relevant voicemail or text metadata that later eras take for granted. In 2004, SMS traffic existed but was not the backbone of communication that it would become. Analysts still checked for text records where carriers retained them, but the spine of the timeline remained voice calls. That kept the evidentiary field clean. It also made the storytelling simple for a jury. This number called that number at this minute, this other number did not. The broader picture that emerged from carrier documents was consistent with the reinterpreted physical scene. There was no parade of unfamiliar numbers swarming Kathleen's phone that weekend, no pattern of stranger contact to suggest an outside intruder. Instead, the logs pointed investigators back toward the circle already defined by access, routine, and opportunity. In towns like Bolingbrook, crime often hides in the spaces between ordinary calls. The timeline here did not solve the homicide. It narrowed the lanes until the path forward was visible. By the time analysts locked this timeline, interview teams had a prioritized list of contradictions to test. They knew which statements required a new round of questions, which alibis held up under the minute marks, and which did not. The digital chapter closed with clarity. The story that would stand in court needed to match the carrier's timestamps line for line. The next step moves from what the phones recorded to what people said, interviews, prior statements admitted under the rules, and how those words worked or failed when set against this clock. With the phone timeline pinned to minutes, it was time to test words against it. Detectives recontacted neighbors, friends, and family to lock down routine, access, and any friction points. Each interview was recorded, time-stamped, and compared to carrier logs from the weekend window. Claims of checking in later that night were verified against dialed numbers. Assertions of being unreachable were checked against whether the handset was actually active on the network. The rule was simple. If a sentence didn't survive the timestamps, it didn't survive. Neighbors described a narrow sequence that began with concern and ended in a welfare entry. Their statements were precise about what they did and when they did it. Their phones reflected that pacing, short coordination calls, then silence during entry, then renewed traffic once responders were on scene. Nothing in those accounts suggested a stranger approaching the townhouse or leaving in a hurry. That aligned with a house that showed no forced entry and little disturbance outside the bathroom. Friends recounted prior tensions from the divorce period, the practical realities of property division, and scheduled court activity on the horizon. Investigators did not need motive to test truth, but those details provided context for access and opportunity. When one source placed a subject out of pocket around dinner, the logs either showed a string of outgoing calls or a handset dark during the same window. Small inconsistencies were noted. Large collisions with carrier records were flagged for follow-up. A separate layer involved prior statements that later reached the jury under the state's forfeiture by wrongdoing framework. Those statements were not used here as headlines, but as items to be matched with the 2004-era clock. Who said a threat was made, who described a plan disguised as accident, and whether any of those claims intersected with routine movements recorded elsewhere. The goal was not to dramatize hearsay, but to hold it up against neutral data. When a statement's timing and opportunity matched the phone gaps in the access profile, it gained weight. When it fought the clock, it lost it. Investigators also pressed on alibi structure. If someone reported being home, yet their phone connected repeatedly to towers more consistent with travel toward Bolingbrook. That contradiction triggered another interview. If a person said they drove a route that would normally generate a short call or two, routine check-ins, but the log showed nothing for hours, that silence was logged as a behavioral gap. Silence by itself proves nothing, especially in 2004, but silence that clears a narrow window of opportunity matters. The interviews were conducted with restraint. Detectives avoided leading questions, kept subjects on the calendar, and returned to the same points from different angles: key possession, door habits, who would be expected to enter without notice, and who had reason to do so. They confirmed that neighbors did not hear a fight, a crash, or glass breaking. They confirmed that no one saw a forced entry. They confirmed that nothing appeared stolen. The picture that formed was not dramatic, it was precise. Access looked controlled. Opportunity looked brief. In total, the interview file read like a series of reconciliations. Statements checked against minutes, recollections checked against routine, and prior remarks, some of them years old, checked against the physical anomalies now treated as central. One investigator's margin note captured the posture. The data aligned too cleanly. Sometimes that's the problem. Clean alignment forced a narrower question, not a broader one. Who could be inside that townhouse without leaving an obvious trace? By the end of this phase, detectives had reduced the narrative to a workable core. A handful of statements stayed intact after the phone and access tests. Others bent under the timestamps or raised new inconsistencies about location and availability. That list set the agenda for legal strategy. Which pieces of testimony were consistent enough to be offered, which required corroboration, and which would not be pursued. Next comes the logistical build of intent and opportunity. Documents, receipts, and calendar pressure that either support a staged accident theory or undercut it. With statements trimmed to what survived the clock, the next move was paper. Records that don't change their story. Investigators pulled the divorce and property files tied to Kathleen Savio and Drew Peterson. The divorce had been finalized the prior year, but orders on property and money were still active, with a hearing scheduled in early March 2004 in Will County. That calendar entry sat almost on top of the weekend when Kathleen died. Prosecutors later framed that proximity as pressure. Litigation poised to resolve assets, custody logistics, and the Pheasant Chase Drive residence. The point wasn't drama, it was leverage. A deadline on the docket is a measurable event. Financial records were scanned for sudden cash withdrawals, unusual credit use, or purchases suggesting staging tools. Public reporting does not identify a receipt that directly tied a purchase to the manner of death. That absence mattered. It meant planning, if it existed, leaned on access and timing rather than a specific bought item. Bank statements and card activity from the period looked ordinary enough to avoid being a standalone exhibit. Ordinary doesn't exonerate, it simply doesn't carry the story by itself. Employment rosters and duty schedules were compared to the call detail timeline. The objective was to determine availability during the narrow window before neighbors escalated concern. In a 2004 file, this kind of reconciliation is mundane but powerful. If a person claimed to be at work when the roster set off or set on shift while the phone was moving like someone off duty, the contradiction flagged quickly. Where the records aligned, detectives noted it and moved on. Where they didn't, a follow-up interview was scheduled. Investigators also looked for travel indicators, airline bookings, hotel confirmations, border queries, anything that might suggest flight or a built-in alibi. There is no public documentation of flights or out-of-state travel tied to the weekend at issue. That negative evidence kept focus local. Whoever caused the homicide crime did not appear to build escape into the plan. In a suburban case without forced entry, planning often looks like routine. Arriving when you won't be noticed, leaving without a mark, and relying on an early accident ruling to close the file. Court filings from the divorce era contained affidavits and motions that, while not proof of violence, described escalating hostility over finances in the home. Prosecutors later used those documents to outline motive and access, who retained keys, who had reason to be in the house, and who stood to gain by avoiding an unfavorable court outcome. The filings gave dates, hearing notices, and orders that could be read aloud to a jury without speculation. They also anchored the tone of the relationship in the months before Kathleen's death, strained, litigious, and focused on property. The planning assessment avoided retrofitting facts to a theory. Investigators matched paperwork to the telecom clock you've already seen. If a person said they were preparing for court filings later that night, the call records either showed attorney contact or they didn't. If someone referenced errands that should generate bank or retail traces within a certain hour, those traces were either present or absent. Small mismatches went in the margins. Large ones went on the board. One through line survived each pass: access, not burglary. No forced entry, no theft, and nothing missing that mattered to the victim. When preparation favors access, planning can be as simple as knowing the house and the calendar. The proximity of the property hearing gave prosecutors a clean line to argue motive without inventing it. The lack of a telling receipt didn't weaken that narrative. It made it more focused on opportunity, means, and the staged accident inference supported by the re-autopsy. By the end of this phase, the planning file was lean and admissible. Court calendars, pending orders, financial posture, and routine employment records. None of it solved the homicide alone, and none of it tried to. It was built to travel with the physical anomalies, the call detail minutes, and the statement tests, each strand modest on its own, stronger together. Next comes the moment the file turns from investigation to accusation. Charging decisions, legal theories, and how multiple agencies coordinated warrants and custody without losing the narrative's spine. With routine reports converging on access and pressure, the case shifted from suspicion to accusation. The Will County State's Attorney's Office reopened Kathleen Savio's 2004 death after the separate disappearance of Stacy Peterson put renewed focus on Drew Peterson. A special grand jury was convened to examine whether a homicide crime had occurred. Illinois State Police, Bolingbrook Police, and the coroner's office coordinated to reconstruct the timeline, reassess the autopsy work, and organize call records for grand jury presentation. The critical turn came when a court-ordered exhumation produced a new autopsy. A board-certified forensic pathologist concluded that Savio's death was not accidental, but the result of homicide. That medical conclusion, backed by chain of custody and controlled evidence, gave prosecutors the foundation they needed to move toward indictment. The charging theory was constructed in 3 strands. First, access. No forced entry and no evidence of an outside intruder pointed to someone familiar with the home. Second, motive. A property hearing and unresolved financial disputes loomed in the weeks before Savio's death, creating pressure. Third, timeline. 2004-era phone logs and limited cell site activity raised questions about alibis and gaps that could not easily be explained. Prosecutors also anticipated legal hurdles. Because Stacy Peterson was missing and could not testify, the state's attorney's team prepared to use forfeiture by wrongdoing principles, arguing that the defendant's actions had rendered a key witness unavailable. They expected challenges over hearsay evidence and worked to frame their case around admissible testimony, corroborated records, and expert conclusions. The interagency approach was deliberate. Illinois State Police managed forensic coordination and lab submissions. Bolingbrook Police supplied local knowledge and preserved reports from 2004. The state's attorney's investigators organized subpoenas and witness appearances, while the coroner handled medical documentation. Each transfer of evidence was logged, ensuring the chain of custody would stand up under cross-examination. Over several months, the special grand jury heard testimony from pathologists, detectives, and witnesses connected to the couple's divorce proceedings. They reviewed documents that tracked Kathleen Savio's legal battles, communications, and financial status. By May 2009, jurors returned a 2-count indictment for first-degree murder, citing intent to kill and knowingly committing acts causing great bodily harm. Drew Peterson was arrested soon after, with bail set high due to the seriousness of the charge and the risk of flight. Charging was not the end of coordination. It marked the beginning of trial preparation. Prosecutors secured demonstrative evidence to explain the difference between an accidental drowning and a staged scene. They prepared motions anticipating disputes over hearsay and exhibits, including whether jurors would see the bathtub where Savio's body was found. In essence, the indictment was the product of methodical work rather than dramatic revelation. Prosecutors relied on medical findings, access anomalies, and a consistent timeline to frame the crime. Agencies adhered to their roles, creating a case structure that could withstand the legal battles ahead. The next stage would be the courtroom gatekeeping. What evidence the judge allowed, what was excluded, and how the story was shaped before a jury. From indictment to courtroom gatekeeping, the file moved under a judge's calendar, and every word had to earn its way in. Pre-trial began with motions that would decide the jury's world. Prosecutors previewed a narrow theory, homicide by a person with intimate access, staged to resemble accident, supported by medical opinion, phone minutes from 2004, neighbor timelines, and divorce court pressure. The defense pressed the opposite, a tragic fall in a bathroom with no eyewitness, no confession, and no forensic item uniquely tying a hand to the act. The judge scheduled hearings on hearsay, exhibits, and bail. Hearsay was the longest fight. The state argued forfeiture by wrongdoing. If a defendant causes a witness to be unavailable, certain statements can be heard. Prosecutors did not lean on rhetoric. They offered dates, sources, and corroboration points. The court did not open the floodgates, but it did admit a limited set of statements after weighing reliability and connection to the alleged acts. The ruling was technical. It did not prove the homicide crime by itself, but it allowed jurors to hear context that could be tested against records. Exhibits were pared down with the same caution. The court excluded the actual bathtub as a physical exhibit, finding the risk of unfair prejudice outweighed its value. Jurors would see photographs, diagrams, and measured notes instead. That forced both sides to argue from documented dimensions and medical conclusions rather than raw optics, which is how a courtroom is supposed to work. Bail remained high. The defendant stayed in custody pending trial. Discovery orders were enforced to the letter. Chain of custody on exhumation materials was reinforced through sworn logs so that any challenge later could be answered with paper, not memory. With those guardrails set, a Will County jury was impaneled in 2012. Opening statements were brief and procedural. The state promised a timeline that would not drift, a welfare check opening a quiet townhouse in Bolingbrook, Illinois, a bedroom and bathroom with no forced entry, a dry tub cataloged in photographs, a death first called accidental, then reclassified as homicide by forensic pathologists after exhumation. The defense promised reasonable doubt rooted in absence. No foreign prints tied to a suspect, no theft, no neighbor who saw an outsider, no conclusive forensic trace. The medical evidence came first. A board-certified pathologist explained the re-autopsy sequence, external injuries, internal findings, and how the pattern fit a struggle more than a slip. Jurors saw scaled photos and heard why bruising, laceration placement, and lack of findings consistent with a prolonged submersion under normal bathing conditions undermined an accident narrative. Cross-examination targeted interpretation. Could a fall account for everything? The experts stayed inside the report and the science. No dramatics, just anatomy and timing. Investigators followed with process. They walked jurors through custody of the remains, the exhumation order, the transport logs, and the lab submission receipts. Any gap, however small, was addressed with signatures and timestamps. When the defense suggested investigative hindsight, the lead detective pointed back to the records that existed in 2004 and the ones generated when the death was re-examined years later. The point was not to defend an early call, it was to show why the later call was made. Neighbors and friends supplied routine. They described the escalation from concern to entry, the quiet of the block, and the absence of commotion. They did not speculate about what happened. They told jurors what they did, what they heard, and when they made calls. Their cell records matched those events within minutes. This was not theater. It was a community's small actions lining up with the clock. Telecom records from 2004 followed the same rule. A carrier representative authenticated call detail and the limited cell site data available at that time. No GPS, no app trails, just dials, durations, and which towers handled them. The state used that modest map to confirm or challenge alibi claims. Where a story matched the minutes, jurors heard it. Where a story fought the minutes, jurors saw the contradiction laid side by side. Financial and court documents came in next. Certified copies showed a property hearing set near the death window and outstanding orders touching money in the house. The prosecutor did not claim a bank slip proved homicide. The point was pressure. The legal calendar bore down in early March 2004, and the victim's death stopped those issues cold. Under cross, the records state exactly what they were, dates and orders, neither more nor less. Hearsay admitted under forfeiture principles arrived in controlled pieces. Jurors were instructed on how to treat it. The statements were not an endpoint. They were tested against timing and access. The judge reminded the panel that they alone would weigh credibility and that the burden rested entirely with the state. By design, the case did not hinge on a single remark. It asked jurors to consider whether those remarks aligned with the measurable parts, medical findings, scene quiet, and the telecom clock. The defense case emphasized uncertainty. Counsel highlighted the absence of a unique physical trace tying the defendant to a fatal act at a precise minute, argued that injuries could be consistent with a slip in a hard-surfaced room, and warned against retrofitting motives onto an accident. The defense pressed the early accident ruling as evidence that trained professionals once saw no crime. On redirect, the state returned jurors to the re-autopsy and the lack of forced entry. In a home without pry marks or broken frames, access mattered more than speculation about strangers. Closing arguments were concise. Prosecutors told jurors the file never promised a spectacle. It promised elements that fit: controlled access, a medical homicide, a property deadline, and a timeline that cut out chance intruders. Defense counsel asked the jury to hold the state to proof beyond a reasonable doubt and to view the absence of a smoking gun as precisely that: absence. The judge instructed on first-degree murder, intent, knowledge, and how to evaluate circumstantial evidence. Then the case went quiet while the jury worked. The verdict came back: guilty of first-degree murder in the death of Kathleen Savio. Post-trial motions challenged evidentiary rulings, including hearsay admissions and exhibit limitations. The court denied relief. At sentencing, the judge addressed term length under Illinois law, considered aggravation and mitigation, and credited time served. A 38-year sentence issued. Appeals followed in the years after, and the conviction stood. The legal system is slow by design. That slowness is a guardrail against impulse. Here, it carried a single conclusion to finality. There is a practical lesson in what reached that jury. The strongest criminal files often look plain: certified copies, phone minutes, diagrams, and ordinary people who remember what happened in their own kitchens and hallways. In towns like Bolingbrook, murders aren't just crimes. They rewire trust on a block where doors used to stay unlocked. A careful verdict cannot fix that, but it can say the facts were heard under rules that protect everyone, guilty and innocent alike. As we close, the name at the center belongs first: Kathleen Savio, mother, daughter, neighbor. Cases like this remind us that accountability is built, not declared. If you've watched a story like this unfold in your own community, you know how long it takes for routine to feel normal again. That's why procedure matters, and why we tell these cases without spectacle. The record is what endures. Guilty. Sentenced to 38 years. Looking back at Kathleen Savio's story, I can't help but see how fragile safety really is when trust is broken inside a home. This crime teaches us that silence and overlooked warning signs can carry a devastating cost. Justice, though delayed, shows us that persistence matters. So I ask you, how do we as neighbors and citizens notice and respond when something feels off? What steps would you take if someone close to you seemed in danger? Share your thoughts below. If this video touched you, let me know where you're watching from, and don't forget, hit subscribe so you won't miss the next story we uncover together.